Okay, I am going to start reading the trial transcripts, starting on page 42 because I've already read the first 40 pages. It says, the court. All right, let's go on the record in the matter. People versus Carver, Owen, and Waterman. All counsels are present. We're outside in presence of the jury. The court has a couple of things it wants to put on the record. I indicated to counsel I do have a family emergency that I need to leave today at noon. My father-in-law is in intensive care in Riverside. I have to take my wife, and I don't know what his prognosis is, so I have to take care of that this afternoon, and I apologize for that. What we're going to try to do is we'll do hardships with our second panel this morning. I've had conversations with the attorneys about what issues we need to resolve, so they are actively vordering the jury. The most pressing issue seems to be whether any gang evidence is going to be admitted or not. That's going to involve testimony of Detective Whitten and Miss Johnson, who just took a plea minutes ago this morning. So that's going to involve a hearing with those folks. We'll get as far as we can do with Detective Whitten today and continue the hearing tomorrow. My intention is once I do hardships with the folks today, I'll tell them to come back on the 24th, and I'll tell the jury tomorrow to come back on the 24th. We could rest with what we have today, and I'll do tomorrow to try and resolve the gang issues so we know what's coming in and not coming in. So you could actively conduct your examination of the jurors, okay? I think we have a supplemental panel, so I'll bring them up and see how far we get. I know there were some discovery issues. Was there an interview that was conducted this morning? Token. Yes, Your Honor. Court. And that's going to be provided to counsel today? Token. Yes, court. And that is of Miss Johnson. Token. Yes, court. Any other issue counsel want to put on the record? Mr. Myers. Just two things. The other discovery issue is, I believe counsel for the people are going to get a copy hopefully today, and that there is no prior statement about this kidnap witness intimidation thing. Just today. There is no previous interview by law enforcement. Token. I could represent that when I spoke with Miss Johnson, she indicated she was in fear of her safety. I, at that point, put her in contact with Investigator Perry, and he talked to her about getting her into witness protection. They have to have had a conversation about the nature or the reason why she was going to be put in witness protection, and at that point is when we decided to have her referred to Banning. As I explained before to counsel, the interview did not take place for whatever reason. It was a miscommunication between Ukaipa and Banning as to who's supposed to take the interview. That was in the morning. When Dan did the interview this morning, now I can't say, obviously Investigator Perry was informed of the nature of it, but he did not produce a report. I will check with him if there is a recording, but I have not received a report from him. The court. Okay, all right, so let's bring up our supplemental panel and see how far we get this morning. Mr. Token. Thank you, Your Honor. Whereupon jury enters the courtroom. Jury order begins. Court. All right. Let's go on the record in the matter of People versus Carver, Owen, and Waterman. All counsel are present. We are outside the presence of the jury. The court has a couple of things it wants to put on the record. I indicated to counsel I do have a family emergency that I need to leave today at noon. My father-in-law is in intensive care in Riverside. I have to take my wife, and I don't know what his prognosis is, so I have to take care of that this afternoon, and I apologize for that. What we're going to try to do is, well, do hardships with our second panel this morning. I've had conversations with the attorneys about what issues we need to resolve, at least so they can actively order the jury. This is 8 pages that are filled in with the same exact thing. That shows me that apparently there was some things taken out of the trial transcripts that the Watermans are not supposed to see. And the 8 pages do pretty good. Our 8 pages all the way to page 48. And other issues counsel wants to put on the record. Mr. Myers, other discovery issue is, I believe, counsel for the people are going, nope, there you go again. Let's see, where's the next one? So, thank you, Your Honor, the court. All right. Do you need time to, okay, here we go. Now we'll start the rest of it. The court. All right. Do you need time to establish the witness as a gang expert, Mr. Token? Well, it was my understanding this morning that the court wants to hear what information that Detective Whitten had regarding the gang. The court. I just want to know if I'm going to let, by the way, we're still on the record outside the presence of the jury. I just want to know before I start letting, there's one thing for a witness to come in and say, I believe they're gang members, and that's why I was afraid to say anything. It's another thing to try to establish that they're gang members to prove aiding and abetting a relationship motive for committing a crime. That's something a little different. So I'm not sure what you're trying to offer. My understanding is it's kind of broad as far as witnesses go. I'm more inclined to do that with as far as trying to establish that each of these three people are part of a gang. I'm going to need some testimony. If you want to use that to show because of their affiliation, it's logical to prove that they were aiding and abetting the commission of a crime, and they had a motive because of an association to commit a crime, and that they shared the intent to commit a crime. I don't know what you want to do as far as that goes. Mr. Token, okay. With regard to Detective Witten coming up with a conclusion based on his expertise, we have not turned any such report or conclusion over to defense, the court. Well, that's why I'm here to have a 402 hearing to flesh out whether he, in fact, has enough expertise to render an opinion, and if so, what that is, and if he can establish by any means whether any of these three people belong to any gang or if they all affiliate with the same one, Mr. Paul Harbour. And, Your Honor, for purpose of the record, I would object to any evidence being presented at trial to late discovery, these being with regard to Mr. Owen and any sort of alleged gang ties. There is nothing, and I mean literally nothing, in discovery that we have linking Mr. Owen to any sort of a gang. There are statements from Ms. Johnson earlier that we do not have that indicates some connection between the other two defendants in an organization called Cross Family Skinheads, but nothing as to Mr. Owen at this point. The court. Well, I guess let me hear this 402 hearing to see what evidence there is and is not, and reestablish themselves as sufficient expertise on this to give me an opinion that they are members of a gang. Mr. Token. Okay, thank you, Your Honor. I'll call Detective Witten. Whereupon Mr. Token exits the courtroom. Mr. Paul Harbour. That doesn't negate my objection with respect. The court. No, but I'll wait for Mr. Token to come back. Mr. Token enters the courtroom with Detective Witten. The court. I was indicating that, well, the last thing is exclusion. The court can do other things besides exclude the evidence. I can give you a continuance to try and figure out what's going on. You'll have about a week from today before I even bring back the jury for jury selection. I just want to hear what evidence there is, and when was that? When I first received information about it, oops, I'm missing a couple pages here. I'll have to stop.